Good afternoon, everybody. Welcome back to Eating the Elephant, our series on Facebook Live, where we break this big elephant of Hurricane Michael down into bite-sized pieces. We're going to talk a little bit about some insurance tips, and we talk about general recovery. Today, we're not going to talk an awful lot about insurance stuff. We're going to go a little bit nerdy. And I want to start with one thing before I get into the meat of the presentation today. And that's something that's really kind of been bugging me over a few days, and I finally I got to say something about it. I've noticed that it seems like now for a couple of firms, I've gotten several calls and emails this week, but it seems like intimidation and bullying has become kind of a standard process for some business people in town. And I have to tell you, I think it's grossly inappropriate. If you're an insurance agent, like me, if you're an insurance company, your public adjuster, if you're a contractor, anyone you sign a contract with, or anyone you have a business relationship with, you're the boss, you're the client, you're the person that brings the checkbook. Even if it's an insurance company's checkbook, that's money I consider prepaid. If you're getting insurance funds, you've earned that money in premium payments, and so I consider that your money as well. And if you've hired somebody and they're belittling you or intimidating you or bullying you, that's just completely beyond the pale. That's inappropriate, and you shouldn't put up with that. And if someone tries to silence your criticism because of that, I don't think you should put up with that either. I think we should call out bad behavior. I think we should chase off the bad players, and I think we should promote the good players in town, because I think that's the best way to chase off the bad players and have fewer people taken advantage of. And promoting the good players in town, I think that's more likely for people to get good work done more quickly at a more fair price. Again, if you are being bullied or intimidated or belittled by someone that you hire, that's not appropriate. You need to find a way to sever that business relationship. And a lot of those relationships are based on contracts, so you may have some difficulty there. But I just want, if you're having one of those am I crazy moments, no, you're not crazy. You need to follow your instincts, trust your gut, and realize that if somebody's mistreating you, that's not appropriate. And if they know more about the situation than you do, that it is part of their job and part of their professional obligation to translate that information into language you can understand and that makes sense to you. Insurance is a very technical subject. Law, construction, you may not have expertise in these fields, but that's why you hire somebody with that expertise. And part of their professional obligation, at least in my opinion, is not only to perform well, but also to explain it and to stay in touch with you in a way that will keep you in the loop, in a way you can understand and be comfortable with. So we're going to leave that. I'm going to post more on that because I really am a little bit disturbed about some of the stuff I've heard about. You'll hear more about that from me on Facebook over the coming days. But I wanted to talk a little bit today about some legislation that just passed. And I want to get my biases out front. I am an insurance guy, and this is insurance legislation that was promoted by the insurance industry. As a matter of fact, it's been kind of on the table for 7 years. The last 7 legislative sessions, the insurance industry has been working to promote legislation like this. And it is to reform the AOB, or assignment of benefits process. I will tell you, people on my side of the fence, a lot of people in the insurance industry will tell you that without passage of this legislation, that the entire world was going to come to an end, that the insurance industry was going to collapse under the weight of the fraud and abuse. I think that's extreme. On the other hand, you got AOB contractors and what I would call bus bench attorneys. Many of those who make money based on assignment of benefits will tell you, now that this legislation is passed, that no one in Florida is ever going to have work done after a hurricane ever again. They're very extreme on both sides. You've had both people screeching. Frankly, neither of those sides are true. The truth is somewhere in the middle. So what I thought I would do today, a lot of people are hearing parts of the story, and both from people that are highly partisan on my side and highly partisan on the opposing side. I thought what I would do is kind of go through the legislation just a little bit. I won't use technical terms, and tell you what the legislation actually says, and then you, as an intelligent consumer of information, can kind of make your own decisions. I think that's what Eating the Elephant is about, is me giving you information and letting you decide kind of the way you think things ought to work. So I'm going to use notes here, so I'll be looking away from the camera a good bit. There's about 19 different little sort of points or paragraphs. It's a little bit longer than that. I'm not going to read the whole legislation because, oh my God, is it boring. And I thank Johnny Bashirs for this. I'm using a lot of his language because I do tend to unknowingly lapse back into insurance speak. So I have borrowed some of Johnny's language and his explanation because I think it's a really excellent layman's description of the different terms in the legislation. So first thing it requires is that an AOB be in writing. Seems pretty reasonable to me. The second thing is that a contractor must notify the insurance company of the assignment. Also a pretty practical thing, and I think that happens already. Neither of those are controversial. Third one is that it must cover only the work that's being performed. A lot of people have talked about a limited AOB, such as for the roof or the mitigation work, so that seems pretty normal too. It must contain large text. And there's certain language about how to cancel an assignment of benefits. I think deciding what kind of text is in a piece of legislation or in a contract is a little bit silly, but if it makes it clearer for homeowners, then so be it. Anything that makes it better and easier on the homeowner, I'm all for. It does allow the homeowner to be liable for the damage or attorney fees or something if the policy prohibits AOBs, and we're going to come back to that. But if a homeowner has a policy that doesn't permit an assignment of benefits and then signs that policy over to a contractor, you're still going to be liable as a homeowner to the contractor for the work they perform. That's not to the homeowner's advantage necessarily, but I have to be honest, it does seem like a reasonable thing to do, and it does protect the contractor. It does not allow an AOB contract to assess a penalty for canceling, withdrawing, or rescinding. A lot of what happens and where we've seen difficulty in the AOB process is someone will sign someone up and then they'll ghost them for 6 weeks. You can, under this, you can cancel the AOB. However, in a lot of AOB contracts that we've seen so far, if you do cancel them, even for good reason, then you have to pay a penalty. Sometimes as little as, say, $2,500, sometimes as much as 25% of the contract price. That's particularly problematic when there's no contract price written in on the contract, and we're going to come to that in a minute as well. It doesn't allow the charging of an administrative fee. Contractors are very frustrated by this because they do have to spend, to be fair, a good deal of time coordinating with adjusters, calling, looking for payments. They take over the homeowner's work, theoretically, in getting the claim handled and paid. And so they often charge administrative fees for that. I don't think that's a great idea. Personally, I feel like if you're taking on this kind of work, then you know what you're getting yourself into and that you're not really entitled to that. You should build that into your cost structure. Although I do see a point. If you're going to do that kind of work and you're really going to provide an additional professional service, then maybe you're entitled to a fee. But I leave that for your decision. This is the most controversial provision probably, and it's the one I've seen most bounced around on Facebook incorrectly. It limits emergency repairs to $3,000 or 1% of the policy limit. And I'm going to leave that there because we're going to finish up with that because I think that warrants a little more thorough explanation. It requires the contractor to maintain and provide records of the work to the insurer. That seems pretty reasonable. They've got to provide a copy of the AOB and they've got to provide copies of their estimates. I think that makes sense so everybody can be on the same page. But that may be a paperwork burden that you as a consumer don't feel is necessary. It does not allow the contractor to collect additional funds from the owner beyond the deductible unless the owner specifically agrees. So you as an owner could sign an assignment of benefits and then ask your contractor, hey, while you're in there, I would like a tile backsplash. I didn't have one before, and I'll pay you additional for that. And I think that's perfectly reasonable as well. That seems like a pretty reasonable provision. Hang in there with me, we're about halfway through. It requires the contractor to testify under oath about his costs and the work done, if need be. So if this goes to, if it gets ugly and it goes to litigation, then you've got to testify under oath. That's an obligation that policyholders have under their policy right now, and it seems to me that if you were going to take the rights of a policyholder, you should probably take over many of their obligations as well. It requires the contractor to resolve disputes according to the policy provisions in the insurance contract, such as arbitration or mediation. And I, again, going back to what I just said, if you take over the rights of a contract, you should take over the obligations as well. It does not allow the contractor to adjust, negotiate, or settle with anyone that the owner does not approve. So if you have a general contractor that hires a subcontractor you don't like or don't trust or frankly are afraid of, you can get that contractor kicked off the job. I think that's a good idea because I think that's additional protection for the homeowner. Contractors have suggested that that makes it difficult on them because they negotiate with certain sets of subcontractors, and that makes their job more difficult. I do see their point, and I think that's a decision for you to make. Or should we worry about the homeowner having control or the contractor being able to work with whom he's most comfortable? Your decision. It does not allow the contractor to sue or collect funds from the owner, place a lien on the property, which I think is key, or file negatively against the owner's credit if it results from the assignment of benefits contract. In other words, once you sign off that AOB, they can't lien your property, they can't file against your credit. That's not the situation we have right now. I like that provision. I think most homeowners would like that as well. And I think that would be a valid reason that a homeowner might consider signing an AOB if they could avoid any of those potential problems later. It does make the owner liable to pay the contractor from their personal funds for the deductible or any betterment. We talked about that a minute ago. It's sort of a repeat, but the language in this particular paragraph makes the earlier stuff a little clearer. It requires the contractor to notify the insurer and the owner if they intend to file suit. That seems reasonable. If you're going to sue me, you should notify me. I don't think that's an undue burden, and that hasn't been a particularly controversial part of the policy. Part of the legislation either. If a suit's filed, the insurance company gets attorney fees in a way that's a little bit more, in my opinion, more fair. The way things work right now, if you as a homeowner sue your insurance company, let's say you think you've got $200,000 in damages, they think you have $50,000 in damages. Well, if you collect $50,001 as a result of the litigation, any gain at all, then the insurance company, over and above your policy, has to pay their own attorney's fees, and they have to pay your attorney's fees. The way this works now is if you do an assignment of benefits and the contractor is working against the insurance company, that it's a little bit more level. If the insurance company wins most of their case, then kind of everybody pays their attorney's fees. If they win essentially all of it, then the contractor pays. So it's a little bit more of a business-to-business sort of situation, and it's a lot more like business litigation normally runs. I think no matter what happens in a litigation between an insurance person, an insured, a homeowner, if you're going against an insurance company, I think we ought to lean that process in your favor as much as possible. And in any possible case, if you win even $1, I love the idea that the insurance company has to pay the entire freight, both for them and for you. The problem is when there's no risk on the part of an attorney firm, a PA firm, or say a restoration contractor, they have absolutely nothing to lose by dragging this thing out and taking it to court. Because if they win anything at all, if they only win $1, then what they can do is the attorney can puff up their fees and get huge fees on top of that. So you could have a very, very small award. You could have an award for $10. And theoretically, the insurance company would end up having to pay $10,000, $20,000, $30,000, $40,000 in legal fees. There are people that think that's a good idea. They want to punish insurance companies for any perceived miscalculation. My perspective on that, of course, is that that does drive up the cost of insurance overall. And every time the insurance company pays out more money, they're going to raise rates. That's the way things work, because they do have to pay the bills. So that's a key part of the legislation. You're going to see an awful lot of discussion on that part, on how these fees get paid. What I do want to be clear on is this only is affected and only comes into effect when an assignment of benefits is signed. If you just sign something with a contractor with no AOB and you want to sue your insurance company, all of the things with regard to who pays the legal fees still lean your direction. It requires insurance companies to report to the state how much money is paid out each year through AOB. In other words, they have to report their data. Insurance companies have brought this legislation to the fore because their assertion is that there's an awful lot of fraud and abuse involved in assignment of benefits. I tend to agree. I've seen a ton of it since the storm hit. People on the other side of that argument, good contractors, good attorneys, their perspective is, frankly, look, you have a relatively small number of people behaving badly. Let's prosecute the fraud there, and we should be able to solve the problem with proper prosecution of fraud. I like that idea. I have to say that in practice, it just hasn't worked, it seems to me. But again, that's a conversation that you should have wider than this particular video, and make your own decision whether you agree that we should be more aggressive in chasing off the bad guys, or if this legislation is going to be an effective way to deal with it. Frankly, I'm a belt and suspenders guy. I think we should do both. Finally, it allows the insurance companies to not permit AOBs if they charge less. So they can have two different policies. They can have one policy that you can assign, and you can have an AOB anytime you want. They can have another policy that's identical to that that doesn't permit assignment, but that policy has to be cheaper. How much cheaper, we don't know. It's going to have to be driven by the data that they are required to report under this legislation, but that'll take a while to catch up. So I got to tell you, I think it's going to be interesting to see in the immediate short term. I want to go back to something that I talked about earlier. I said I was going to come back to the $3,000 limit. And this is being mischaracterized online, and I want to make sure that people understand what it is and what it is not. It doesn't. What's being told to people is that you can only spend $3,000 on mitigation now. That's it. I have to tell you that's 100% false. That is something I've heard from more than one attorney, and it's simply not true. What it does do is if Saturday night you have a pipe unzip and you call a restoration company and you're in a panic on the phone and you sign an assignment of benefits, they're limited to what they can spend for that emergency cleanup to $3,000 or 1% of your coverage A until you notify the insurance company. The insurance company, before you tear out half the house, has to have an opportunity to come and take a look at the damage. What we have seen, and part of the fraud problem that we've seen, particularly in South Florida prior to the storm, was you'd have a water leak of some kind, and they'd call a restoration contractor in who would tear out an awful lot more than needed to be torn out. And that gets very expensive, and it's also inconvenient for the homeowner. It might be great if a homeowner gets a new kitchen, they might want that, but it seems a little bit extreme if there's a very small water leak under the kitchen sink, which might be able to be cleaned up with, say, redoing a little bit of the hardwood and maybe doing some repair on the cabinet. I don't know about the specific situation. However, what it doesn't do is it doesn't limit your recovery to $3,000. Two ways you can avoid that $3,000 limit just like this. Number one, report it to your insurance company in a timely manner. Once they're in the loop and you've signed an AOB, the AOB contractor and the insurance company work together, and they can go beyond that $3,000 limit. The second way that you can avoid that $3,000 limit is just don't sign an assignment of benefits contract. Do not sign an AOB, and that's something I've been trying to talk you guys into for weeks and months now. So I wanted to be clear on what that provision is and isn't, because it is being mischaracterized an awful lot online, on social media, particularly on Facebook. Now, all that I've told you, you need to go research yourself. I would encourage you to do more homework. I would encourage you to learn more than just the things I'm going to tell you. Read the legislation if you want to. It's deadly dull stuff. But I would say that the provisions, other than that $3,000 limit and the attorney fee statute, those two things are the most controversial. And those are the things that you're going to see the most misinformation on. And I would encourage you to do your own research and ask lots of questions. Do some more reading. Sorry for the sort of extra nerdy post today. I promise we'll get back to some more mechanics on Wednesday. I do hope you've been able to enjoy this fantastic weekend. Get out to the beach, get out on the boat, at least get outside, get your kids off their devices. That's the challenge that we've had. Regardless, I hope you enjoy yourself. I hope you enjoy the rest of the week, and we'll see you on Wednesday.